Silicon Valley is getting hit with a tidal wave of antitrust lawsuits from US regulators who argue that Google, Meta, Apple, and Amazon are illegal monopolies. In 2 of the cases, federal judges have already agreed, opening the door to a government breakup of some of the world's biggest companies. But could this really happen?
And why?
And how did we even get to this point? Today, we have all the answers. My name is Guy, and you're watching The Coin Bureau. The last time the US government took big tech to task over a monopoly, it was 1998, and Microsoft was ruling the PC operating system market with an iron fist. Depending on how you count, Microsoft's Windows operating system enjoyed a market share of somewhere between 80 and 95%. Unsurprisingly, the government believed that Microsoft had monopoly power, and more specifically, it accused the company of using its power to squeeze Internet Explorer rival Netscape out of the market. Now, Netscape, which was available for multiple operating systems, was the most popular web browser of the mid-1990s, commanding a market share of 86% by 1996. It enjoyed its own network effects, where its large user base made developers want to write applications for it. And the more applications there were, the more new users Netscape would attract, and so on and so forth. At this point, it was clear that the internet was the next big thing, and Microsoft perceived Netscape as a nascent rival platform that threatened to erode its own market position. Although Netscape preceded Internet Explorer, so it was really the other way around. But either way, Bill Gates was not going to take a threat to his software monopoly lying down. Microsoft's launch of Internet Explorer in 1995 was remarkable not because it was a particularly good web browser, but because its distribution model involved a variety of anti-competitive practices designed to cut Netscape out of the market. These included, for example, entering into contracts with PC manufacturers to prevent them from bundling Netscape with their computers, or from making Netscape the default web browser. Similarly, Microsoft had contracts with developers that offered them better deals if they didn't develop products for Netscape. Now, depending on the circumstances, contracts like these can be perfectly legal, but in this case, the court found that they were anti-competitive tactics without legitimate economic justification, used by Microsoft to maintain an illegal monopoly. Now, the most powerful tool available for remedying US antitrust violations is a structural remedy, aka a breakup. And that's exactly what the judge ordered in this case, and Microsoft was told to split its web browser business and Windows operating system business into 2 separate companies. Microsoft, however, narrowly avoided this fate on appeal, but the case nevertheless had a lasting effect on big tech. The finding that Microsoft was an illegal monopoly established clearly that antitrust principles apply to big tech corporations trying to corner the software market. Whether you're selling oil, steel, or code, you can't try to prevent others from competing with you and expect to do so with impunity. According to David Boies, the lawyer who represented the government in the Microsoft case, the ruling helped to establish the competitive market that gave us Google. Sounds like the judge narrowly saved us from having to add Bing to the dictionary as a verb. Anyway, a more indirect but no less important outcome was that Microsoft was preoccupied with fighting the US government in court from 1998 to 2001. This gave the company a pretty full plate during a major inflection point in the market when mass adoption of home computers and the internet was exploding. As a result of Microsoft's preoccupation with legal problems during this period, competitors like Opera and Firefox, which was a kind of successor to Netscape, were able to get a foothold in the market. Real competition to build the best web browser ensued, and Internet Explorer eventually lost its lead to Chrome in 2012.
Well, hello there. I know you're enjoying the video immensely, but I just very quickly want to tell you about the Coin Bureau deals page. Now, if you're looking for some of the very best deals and promos in all of crypto, such as, for instance, up to $100,000 in sign-up bonuses and up to 60% in trading fee discounts on some of the top crypto exchanges out there, as well as insane discounts on hardware wallets and much more besides, then check out the Coin Bureau deals page in the description below. And now, back to the video.
Now, after the landmark Microsoft case, Google burst onto the scene, ensuring that Microsoft was not going to own the internet alone. At the same time, Apple became another major competitor. In the early social media landscape, meanwhile, MySpace was supplanted by Facebook, Google stepped into the ring with Google+, and they all coexisted to some extent with Twitter and others. And, just so you know, viewed from Washington, it looked like there was plenty of healthy competition in Silicon Valley. So perhaps this explains why big tech didn't attract too much antitrust scrutiny from the government during this period. But this all changed during the first Trump administration, when the role of social media in controlling the flow of information online came under intense scrutiny. Trump became the eye of a storm of criticism of social media platforms from across the political spectrum. Critics variously alleged excessive content moderation and censorship of free speech, or negligent moderation and publishing of hate speech, misinformation, and disinformation, among other complaints. And this is how regulation of big tech became a matter of bipartisan consensus in Washington. In 2017, President Trump's Department of Justice appointed Makan Delrahim as Assistant Attorney General for Antitrust, a figure with a colourful history of working for both sides of antitrust cases. He'd worked on the 1998 investigation into Microsoft before being appointed to the DOJ in the Bush administration and then the FTC under Obama. After that, he had a successful stint lobbying for Big Pharma, Big Insurance, Big Telecoms, and Google. In late 2016, he commented on AT&T's controversial proposal to acquire Time Warner for $85 billion on Canadian TV, saying, quote, "I don't see this as a major antitrust problem." Months later, he was appointed as Attorney General for Antitrust at Trump's DOJ, where he was expected to continue singing a pro-merger tune, but he instead quickly filed a lawsuit to block that very acquisition. It seems like rather strange behavior, but perhaps it's a sign of how quickly battle lines were redrawn after Trump first took office. Well, anyway, Delrahim and Attorney General William Barr became the unlikely pioneers of the current wave of antitrust litigation in the US. In 2019, the DOJ launched a broad antitrust investigation into Google, Amazon, Apple, and Facebook. Barr and Delrahim joined forces with a coalition of US state attorneys general, leading to state-level lawsuits against some of these companies. The investigation culminated with the House Judiciary Antitrust Subcommittee releasing a 450-page report in October 2020 accusing the four companies of abusing monopoly power and calling for a revival of old-fashioned breakups and presumptive merger bans. This report laid the groundwork for a newer anti-monopoly framework that recognized non-price-based consumer harms and was more open to structural remedies like breakups. In accordance with the report's findings, the DOJ launched a lawsuit accusing Google of running an illegal monopoly controlling web search and search ads in October 2020. And in December of that year, Trump's Federal Trade Commission launched its own ambitious lawsuit against Facebook, now Meta, that accused it of illegally monopolizing personal social networking services platforms. The Biden administration picked up where Trump left off, with Biden notably appointing a trio of dyed-in-the-wool Trustbusters at the DOJ, FTC, and the White House. FTC Chair Lina Khan, Assistant Attorney General for Antitrust Jonathan Kanter, and Biden's big tech antitrust czar Tim Wu were dead serious about breaking up Silicon Valley rather than just tinkering around the edges. However, they are now all out after a shake-up under the second Trump administration. FTC Chair Khan was replaced with former FTC Commissioner Andrew Ferguson, while the new DOJ Antitrust Division is headed by former Fox Corporation executive and J.D. Vance advisor Gail Slater. And while we're on the topic of the FTC, you might want to pay attention to Trump's attempted firings of its two Democratic Party commissioners, Alvaro Bedoya and Rebecca Kelly Slaughter. This plainly violated the FTC Act of 1914 and the 1935 Supreme Court ruling holding that FTC commissioners can only be removed by the president for inefficiency, neglect of duty, or malfeasance in office. The White House didn't suggest any such reason and only informed the commissioners in an email, quote, "I am writing to inform you that you have been removed from the Federal Trade Commission effective immediately. Your continued service on the FTC is inconsistent with my administration's priorities. Now, dear viewer, you may at this point be wondering, why should I care? Well, for one thing, it could trigger a chain of events that ends up rocking the crypto market. All right, bear with me on this. So, Trump's attempted firing of 2 FTC commissioners is part of a broader push by the White House to bring independent agencies under the control of the president. He's so far issued 2 executive orders trying to expand his own authority in this area and fired officials at other independent agencies in plain disregard of the law and a Supreme Court ruling that says he can't do that. Recently, 2 federal judges rejected 2 of these firings, but Trump is not giving up and continues publicly pining for control of the Federal Reserve, which is kind of the crown jewels for a president seeking to influence federal agencies. The way things are going, one of these cases could end up in the Supreme Court, which should have the final word over whether presidents can, in fact, do this. If the court says yay, then Fed Chairman Jerome Powell could be toast, with significant consequences for monetary policy and therefore for crypto. And for our full report on the Trump-Fed psychodrama, you can check out this video over here, by the way. Anyway, Commissioners Bedoya and Slaughter are now suing the president for illegally trying to fire them. But until that's resolved, the 3 MAGA FTC commissioners, alongside Trump's new DOJ, are pressing ahead with the antitrust agenda that began during his first administration. They're expected to be more hostile to corporate power than Republican commissioners of old, but they're also less uniformly in favor of breakups than the Biden FTC and DOJ were. There are also questions about how Trump's personal relationships with the heads of big tech companies may influence antitrust enforcement. The FTC's case against Meta, for example, went to trial this month after longtime Trump enemy Mark Zuckerberg's strenuous efforts to insinuate himself into the president's inner circle and get the case dropped ended in failure. And this begs the question of what will happen to the investigation of Amazon, launched and aggressively pursued by the Biden-era FTC. The case is in pre-trial stage and is expected to go to trial at the end of 2025 or in 2026. That means there is still time for Jeff Bezos to accomplish what Zuckerberg couldn't, namely preventing the case from going to trial by smooching the ring. Bezos is another long-time Trump nemesis who, unlike unlucky Zuck, has successfully made it into the president's good books. Their new relationship passed a stress test in late April after an apparently rogue division of Amazon proposed to show customers how much of a product's price is made up by Trump's tariffs. Trump saw this on the news and was incensed. He called Bezos, and within hours, Amazon announced that it would do no such thing. Trump said, quote, "Jeff Bezos was very nice. He was terrific. He solved the problem very quickly, and he did the right thing. He's a good guy." Meanwhile, fired FTC Commissioner Bedoya recently told the Colorado state legislature, quote, "I think it's interesting that the last public statement I made, before the firing, was critical of one of the men standing behind the president's shoulder at his inauguration. I issued a statement criticizing Mr. Bezos for working his people in warehouses so fast, so hard, that they literally have to put up vending machines on the warehouse floor, dispensing and capping the amount of painkillers each of those workers has to get." Interesting. Rest assured, we'll keep an eye peeled on the Trump-Bezos relationship, so you don't have to. But now it's time to turn to Google and Meta. What are the cases against them really about, and what could be their fate? I'll start with Meta. The trial started in April and is expected to last 8 weeks. At the center of the FTC's case are Facebook's acquisitions of Instagram in 2012 and WhatsApp in 2014. The FTC argues that these deals established an illegal monopoly over personal social networking services, which has raised a few eyebrows because it was the FTC who voted unanimously to allow the acquisitions to go ahead in the first place. One of the reasons the FTC declined to prosecute at the time was because consumer harm was still narrowly defined in terms of price. But there is now a lot of support for updating this definition to account for the consumer harms inflicted by distributors of free software like Meta & Co. Anyway, The Commission now recognizes the transactions as anti-competitive behavior, and it's relying heavily on Zuckerberg's own emails to prove it. The FTC's lawsuit alleges that he wrote in a 2008 email, quote, "It's better to buy than to compete." In 2012, he emailed a colleague, quote, "We really need to get our act together since Instagram's growing so fast. They could easily copy what we're doing now." After closing the deal, he celebrated by explaining to a colleague in another email, quote, "Instagram was our threat. One thing about startups, though, is that you can often acquire them." The nature of Facebook's acquisition of Instagram, at least, seems pretty clear from these emails. However, the FTC may have shot itself in the foot by also resting its case on a dubious definition of Meta's competitive market contrived to support the existence of a monopoly. The FTC claims Meta competes with Snapchat and a minuscule blockchain-based social media app called MeWe, but not X, LinkedIn, TikTok, Reddit, or YouTube. This would give Meta an 80% market share with little meaningful competition. But in coming up with such a counterintuitive definition of the market, the FTC has arguably hurt its case. Moreover, unlike Microsoft's successful hit job on Netscape, the FTC's case against Meta has no dead bodies to help back it up. Microsoft cut the market leader out of its own market with clear implications for consumer choice. But it'll be harder to demonstrate consumer harm done by Facebook acquiring a company it expects to emerge as a competitor in the future. Indeed, the case against Meta was initially thrown out by the judge based on a lack of facts, and later allowed to go ahead only in a revised form. The same judge also indicated to the FTC that it will be fighting an uphill battle on this one, and at the moment we tend to agree. We therefore think it's unlikely that this particular case will lead to a breakup of Meta. Google, however, is another story, because it has a market share of about 90% of the US web search market, as pretty much any fool could tell you. It has also cornered the world market on online advertising tech. Concurrent trials in the US have now established that Google runs illegal monopolies in both search and ad tech. In the former case, Google's anti-competitive tactics resemble those used by Microsoft in the 1990s. For example, paying Apple $20 billion per year to have Google as the default search engine on the iPhone, and entering into contracts with the likes of Samsung, LG, AT&T, and Verizon to similar ends. This was how the government got Google, although it would have been nice if they'd also tried to prove in court that Google has abused its captive market by allowing its search engine to become a dumpster fire of AI slop, where it's increasingly hard to find useful information. But I digress. Now, there was initially skepticism that the cases against Google would end in a breakup, but this outcome has become more likely now that both cases have proven the company is running illegal monopolies. All that's left now, aside from fending off Google's appeals, is to decide what should be done about them. The DOJ has signaled a willingness to seek breakups, and there have even been suggestions that Google might proactively separate its ad network, Chrome, and maybe even Android to preempt further legal action. Google's appeals may end up in the Supreme Court, where a decision could shape the future of antitrust law in the US and indeed around the world. However, any final remedy may not be implemented for years due to the complexity of targeting specific components of the software ecosystem that forms Google's business. But if a breakup does happen, it likely won't be the last. And if a cascade of breakups takes place, it could in fact be bullish for the companies involved. That's according to Deepwater Asset Management, who believe that a breakup could unlock a significant amount of shareholder value. This is based on the idea that company assets like YouTube and Waymo, which analysts don't typically try to value independently, may be worth more than they're currently priced at under the Google, or if you like, Alphabet umbrella. This is all totally speculative though, and frankly, nobody has suggested that YouTube or Waymo are going anywhere for the time being. Like I said, these cases will take years to be resolved, so don't go holding your breath. Breaking up the Death Star takes much longer in real life than it does in the movies. So while you wait, why not check out our latest report exposing insider trading on Capitol Hill? Now, there's something that really needs breaking up. Okay, that's all from me for now. As always, thank you for watching, and I'll see you next time. This is Guy, over and out.